Now we'll be going for, we have started with the Arbitration and Conciliation Act of India, 1996, right? Yes?
Yes, sir.
Yeah. So in this, we had done one definition also about what is a court, and also we had talked about what is international commercial arbitration. We'll not go into too much into this, right? So we don't need to. So just few points here and there, and then we'll go into the amendment part. The amendment part is important, right? So there is some amendment in 2021, which we need to go in details. So let's slide down. So just write section 8 of this same Act of India. Power to refer parties to arbitration where there is an arbitration agreement. So it could be possible that the various parties, they directly approach the court, right? Even if there is an arbitration agreement contained in the agreement between the two parties. So what the court will do in this case, right? So power to refer parties to arbitration where there is an arbitration agreement. Okay, a judicial authority before which an action is brought in a matter which is subject to an arbitration agreement. Okay, if a party to the arbitration agreement so applies. Not later than the date of submitting his first statement on the substance of the dispute. Okay, just write this, then we see what it means. Then, notwithstanding any judgment, decree, or order of the Supreme Court or any court, refer the parties to arbitration.
So, but like you said yesterday, that the ship broker is also acting as a medium of arbitrator.
He's not an arbitrator. He's trying to mediate, right? Between the two parties, right? So the broker is like an agent, isn't it? He helped you to fix up the.
He will only suggest you that you can go through this.
So you also approached him. The broker was also in contact with the charterer, on basis of which the agreement was worked out. So now, in case of the execution of the charter party, any dispute comes with regards to demurrage, with regards to dispatch, with regards to freight. So the broker will try to negotiate between the two parties, try to mediate between the two parties, right? Try to find a common solution.
Yes.
If this common solution is not found, then the option as per the agreement, if you have the arbitration clause, is to go for arbitration.
Okay, sir.
But in case you directly go to the court, and if one of the parties says that no, there is an arbitration agreement, then the court will direct you to arbitration first.
Okay, sir.
Everybody done with this? Can we go on?
Yes.
Yeah. Next, we will go into where you can, challenge the arbitration award. Right. So we had already said that the arbitration award is final and binding, but there will be certain cases where the award can be challenged, where there can be an appeal against the arbitral award. So for that, we will go to your chapter 7, right? So just write chapter 7 of this act, recourse against arbitral award. Okay, so in general, we said that this is the full and final, but there are certain cases where you can, approach the court to set aside the arbitral award. Okay.
In case of fraud.
In case of, fraud will be fraud, bribery, those will be the terms which we will see in the 2021 amendment. Let us see what is there in the initial act, right? So this is your section 34, application for setting aside an award. Okay. So here, from here, right? An arbitral award may be set aside by the court only if the party making the application furnishes proof that a party was under some incapacity the arbitration agreement is not valid under the law to which the parties have subjected it to.
Sir, set aside means cancel the award, sir.
That is, come again.
Set aside means cancel the award, not issue the award.
Which one? Incapacity.
Set aside the award means cancel the award.
Set aside the award, yeah, means putting a, yeah, set aside the award will mean that you are putting a stay on the award, right? So the award
Put a hold, a kind of hold on the award.
Yeah, stay on the award, right? Hold on the award. So you are not going to allow the execution of the award.
Sir, but both had went knowingly to the arbitrary with both sides.
Yeah, but if one party feels that the arbitration was not done in the proper way, or if one party feels that this the dispute did not qualify for arbitration, or the law which was the law under which the arbitration was carried out was not valid for this purpose. So you can see out of the two parties, even one party can go and approach the registrar. And if he approaches the registrar, the other party has to come forward. If the other party does not come forward, the registrar is appointing the arbitrator. So the whole arbitration process is automatically going ahead, right? So if there is an agreed party, so where he is going to go? He is going to approach the court, right? Okay.
Okay.
Arbitral award may be set aside by the court if the party making the application furnishes proof. So onus is on that party to furnish the proof that the party was under some incapacity, the arbitration agreement is not valid under the law to which the parties have subjected it to, the party making the application was not given proper notice of the appointment of an arbitrator, the arbitral award deals with a dispute not contemplated by or not falling within the terms of submission to arbitration. So supposing the award is going beyond what was the scope of the dispute. So these are the cases where you can make an appeal to the court to set aside the arbitral award under section 34. Okay, let me know once you're done with it, right?
Yes, sir.
Sir, just wanted to know that the arbitral award will be set aside only when the party makes the party who is making the application has the reason, or against whom the application is made, that person also, if has some reasons, then
any of the two parties can approach the court. Whoever approaches the court must furnish the proof, right? So any of the party to the dispute may approach the court once the final award has been made. So once the award has been made, obviously the one who is not satisfied with the award will approach the court before the execution of the award, right? And he will approach the courts with some proof, and the proof related to this. Is it okay?
then this one which is written, the party making the application, this means the party who is approaching the court for the arbitral to be set.
The application means the party who is approaching the court. Okay, the party which moves the court. Okay, you have to apply, isn't it, to the court. So which party approaches the court, which party moves the court, the onus is on that party. which wants some kind of a reprieve from the court to set aside this award. Okay. Yes, please.
Okay, sir. Okay.
Right. Next, just write down, add up a few more things. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties. So you are questioning the setting up of the tribunal. You are questioning the application of the law itself. You are questioning that the award is going beyond the scope of the dispute. So these are the cases, right? Okay, and the second case is where the court itself finds. This is where the party is giving this is where the court finds that the subject matter of dispute is not capable of settlement by arbitration under the law for the time being in force. The arbitral award is in conflict with the public policy of India. So it goes against the law, it goes against the public policy of India. So then the court can set aside the arbitral award.
ये लास्ट वाला समझ में नहीं आया सर, वो उसको इंडिया गवर्नमेंट को क्या प्रॉब्लम होगा आर्बिट्रल को?
And India का जो public policy है, right? Say supposing if I say the arbitration will only be for those commercial disputes. So disputes which have been termed as commercial under the Indian Act, only those will be dealt with.
Okay.
So there can be certain technical issues with what was the award and what is the policy of India, right?
Okay.
So policy is what you are following. That is the law of the country, right? So if it is going against that, then the court can set it aside.
Okay.
In other words, wherever the tribunal has made a mistake, wherever the constitution of the tribunal was itself wrong in the first place, where the law was not proper, where the tribunal exceeded what was the right of the tribunal with regards to the award, right? Yeah.
Yes, sir.
Okay. Next is this, right? An application under this section. So if you have moved the code, then the application under this section shall be disposed of expeditiously and in any event within a period of 1 year from the date on which the notice is served upon the other party. So how much time the court will finally take to decide whether the award is implementable or not implementable is 1 year. So you can get up to 1 year stay, right? Is it okay?
Sir, I had one doubt, sir.
Yeah.
When will the parties move for arbitration? There are many conventions and from where the party can claim the money from the ship owner or any other party.
Okay. See, where the contract itself says that the amount is to be decided by arbitration, then go for arbitration. Where the contract says that if there is a dispute, supposing there is a dispute regarding your demurrage. Why? Because you are saying that no, that day it was raining, and he is saying that no, it was not raining, that day will be counted. So these are the issues, right? So there are disputes here. When you gave your NOR, after how much time of the NOR your lay time should have started. So there is dispute regarding that. So whatever the disputes which come, if in the contract it is written that any dispute will be settled by arbitration, then there is scope for arbitration. Remember, we had a huge list of where we can go for arbitration. If the two parties agree and one is asking for something, the other is giving exactly that much, there is no need for arbitration. But where the calculation of the amount is in dispute, then go for arbitration, right? Okay.
Sir, the arbitration
If somebody
clause.
is not willing to pay you anything, right, then the possibility that you can exercise maritime lien by getting the vessel arrested under the Admiralty Act. Is it okay?
Yes, sir.
Sir, this clause of arbitration need not be only in charter parties. Can it be in bill of lading or contract of affreightment?
Correct, anywhere.
Okay.
Right? So we had a huge list, isn't it? Bill of lading, contract of affreightment, your salvage contract, right?
Okay.
Okay. Next is chapter 8. So chapter 8 also will have two important sections. So section 35 talks about the finality of the arbitral award. Okay. An arbitral award shall be final and binding on the parties and the persons claiming under them. So this clearly says, 35 says that this award is final and binding. Okay. So where is the loophole? Which section is creating the loophole? Section 34.
34.
Right? So if you are asked about that, where is the loophole? Is the arbitral award final? Yes, it is final and binding as per section 35. But the section 34 is creating a loophole where you can delay the enforcement of the arbitral award by moving the code. Correct? Yes, please.
Yes, sir.
Yeah. Next, come to your section 36, which talks about the enforcement. Where the time for making an application to set aside the arbitral award under the section 34 has expired. So there will be a time frame by which if you want to challenge it in court. So where the time for making an application to set aside the arbitral award under section 34 has expired, then what will happen? Such an award shall be enforced in accordance with the provisions of the Code of Civil Procedure. In the same manner as if it was a decree of the court. So as if it is an order of the court. Is it okay?
Yes, sir.
Yeah. Now, what the next line says is just by moving an application in the court does not give you an automatic stay. The court has to decide whether to stay the award or not. So where an application to set aside the arbitral award has been filed in the court under section 34. Okay. The filing of such an application shall not by itself render the award unenforceable. Unless the court grants an order of stay of the operation of the said arbitral award. So you have to get a stay. You move an application and get a stay from the court. Then the enforcement of this arbitral award will not take place for the time being till the time court decides. And court can take a maximum 1 year. Okay?
Yes, sir.
But no automatic stay will take place.
Yes,
Is
sir.
it okay?
Yes, sir.
So shall we go on? Yes, please.
Yes, sir.
Yeah. Next, chapter 9 talks about appeals. This is the last one which we'll do from here. Chapter 9 talks about appeals. And in that you have got a section 37, which talks about appealable orders. An appeal shall lie from the following orders: to the court authorized by law to hear appeals from original decrees of the court passing the order. Means one court has passed the order and now you can appeal to another court. Okay, so one court decided against you, now you are going for a further appeal. So when that is possible? First, when refusing to refer the parties to arbitration, granting or refusing to grant any measure, immediate measures, right? Setting aside or refusing to set aside an arbitral award under section 34. So just see this third point. So supposing the court which you approached, say you approach the district court and the district court says that no, I will not stay the award. Can you appeal to the High Court? Yes or no?
Yes.
Yeah. So you can appeal to the High Court. And supposing the district court has stayed the order, then the other party can still approach the High Court to lift the stay. Is it
Yes,
okay?
sir.
So, means the legal course is in action now.
Sir, can you explain again the appealable orders? Can you explain one more?
Come again, explain. Appealable orders. Right?
Appealable orders.
Yeah, in appealable orders, there are 3 points, but what we are interested is the third point, because this is what you'll be asked, right? Can you appeal against the arbitral award? Yes, you can appeal against the arbitral award. Where is the loophole? Section 34. Otherwise, it is final and binding. Final and binding as per section 35. It says finality. Final, binding, these are the words they have used. But in 34, it is saying that you can appeal. When you can appeal, so then it is giving some of the points on basis of which you can appeal, right? And if you appeal, then the court can take maximum 1 year for disposition of the case. And it can also grant you immediate stay on the implementation of the law. Now, supposing one party has got the stay, other party may not be happy. Or supposing one party went for the stay, but the district court did not give you the stay. So if the district court did not give you the stay, then you are not happy. So can you appeal against this court to the higher court? So that is what is being talked about in 37. So if you see, setting aside or refusing to set aside an arbitral award. So supposing the district court set aside the arbitral award, then there is one agreed party. If the district court did not set aside the arbitral award, then there is another agreed party. So any of them can now approach the High Court, the next higher court, right? So these are appealable orders. Is it okay? Yes?
Yes, sir.
So you can go against the district court and approach the High Court. Can you go against the High Court and approach the Supreme Court?
Yes.
Supreme Court is always the topmost, isn't it? So just see the last one. No second appeal should lie from an order passed in appeal under this section. So you cannot make another appeal in the High Court itself that no, I want a division bench, I want a 5-member bench, 7-judge bench. No. Only one time appeal to the High Court. But nothing in this section shall affect or take away any right to appeal to the Supreme Court. Okay, so after that, still the option to go to the Supreme Court.
Okay, sir.
Is it okay? Done with this? Everybody?
Yes, sir.
Yeah, good.
Yes.
So I'm closing this one. Now we are going for the amendments, right? So just write, this is the last and the most important part. Recent addition to pro-arbitration outlook. Pro-arbitration. India wants to become the hub for international arbitration. So government has taken certain steps and brought in the Arbitration and Conciliation Amendment Act 2021. Okay, Arbitration and Conciliation Amendment Act 2021. Third amendment of the Act of 96 in the past 6 years. Okay, So probably people are questioning that, whether the government itself is sure about what is to be done. Sometimes it is bringing an amendment and sometimes it again undoing the amendment by another one. Whatever the case, right? So this is the third amendment in 6 years. Okay. And the intention is to make India an arbitration friendly regime. So somewhere in the League of France to be the hub for international arbitration. Okay. So amendment has two primary changes in the Act. So what are the two primary changes? First, to enable automatic stay on awards in certain cases where the court has prima facie evidence that the contract on which the award is based was affected by fraud and corruption. The contract itself was affected by fraud and corruption. So then, based on the prima facie evidence, the court can automatically stay the award. So they have used two words, fraud and corruption, but they have not taken the trouble to define fraud and corruption. So it is up to the interpretation of the court.
मतलब आर्बिट्रेशन कमेटी पे वो हो गया, उंगली उठा दी है फ्रॉड एंड करप्शन.
नहीं, आर्बिट्रेशन कमेटी का जो फ्रॉड करप्शन है उसके लिए तो अपील करो एंड रिमूव द आर्बिट्रेटर, राइट? Here the contract itself, the contract between the people was based on fraud, was based on corruption. Okay.
Okay.
Right. Second is there is a change in the 8th schedule omission from the Principal Act. Just write this 8th schedule's omission. What was there in the 8th schedule? 8th schedule was you having a huge list of what will be the qualification of the arbitrator. 10 years in the as a practitioner of law, right? So many things, right? So each one about 10 years and this, that. So you needed large experience. And plus, one of the big difficulties was that it was framed in such a way, the qualification of the arbitrators, that only an Indian could become an arbitrator. So if a foreign lawyer wants to practice here as an arbitrator, it was a hindrance. Then how you promote foreign arbitration in India? So the whole, the whole of the 8th schedule is now out. So there is now no more requirement for qualification, experience, and norms for accreditation of arbitrators, in the sense that now anyone can become an arbitrator, as long as he is a person of integrity, as long as he is of sound mind, as long as he is above 18 years of age, he can become an arbitrator. Then if you are going for marine arbitration, if you are going for some other arbitration, then obviously you require some kind of experience in that particular field. Is it okay?
Yes, sir.
Others, please, all good? Can we go on?
Yes.
Yes, sir.
Yeah. Okay. So this amendment to section 34, bringing in the fraud and corruption, right, is the most significant change in the Act. Okay, so just remember this, section 34, the changes that in case the contract itself was on the basis of or was affected by fraud and corruption, even if there is a prima facie evidence, the court can go by it and stay the award. Okay. Shall we go ahead? Yes, please.
Yes, sir. Okay.
Next is your widening the scope of qualification of arbitrators. So just write this one. That is that second point which you wrote, removing the qualification part, right? So widening the scope of qualification of arbitrators. So these are the important points to say. So there was a 2019 amendment which was the previous amendment, same government, which had added a section that stated the qualification, eligibility, norms of accreditation of the arbitrators. And that section referred to the 8th schedule. Okay, so there was 10 years experience in scientific, technical stream, 10 years as lawyer, right? So many things were there. So those were the minimum qualification of arbitrators.
तो वो जो लंबा चौड़ा लिस्ट था वो 2019 में ऐड किया था और 2021 में इसको हटा दिया.
वापस हटा दिया because they realized that India is further slipping down in the friendly nations for foreign arbitration. Why? Because foreign arbitrators cannot practice in India. So why will the foreign arbitrators, why will any foreign contract refer to Indian laws? Right?
Okay.
Because they cannot have the representatives arguing on their behalf in Indian arbitral tribunal. Okay? So that was the issue, right? And they could not qualify as arbitrators also. So those were some of the issues. Now,
so for foreign flag companies, why will they include Indian arbitration clause in their contract? They will include their country arbitration clause. No?
See, actually, those countries which are friendly for arbitration means where the arbitration will be fast and fair and transparent. So the parties normally choose those countries. It is not necessary that you have to choose your own country, right? So mostly you will see that most of the arbitrations carried out in France, right?
Okay.
So this section, that is the 8th schedule and this 43J, this right from here. This section, among other things, limited the ability of foreign lawyers from acting as arbitrators in India. And this was seen as a significant hurdle when compared to arbitration-friendly states like France.
So, but any foreign nationality coming to practice in India has to be in that list of arbitrators, correct?
Yeah, has to be in the list of arbitrators. But now we will have various arbitral institutions. And these arbitral institutions, like the ICA, which had the arbitration committee. So when they are making the panel, presently they are unable to include, or they were unable to include any arbitrator who is not from India. But now they can include foreign arbitrators also. Yes or no? In their panel?
Yes, sir.
Yes, sir.
Right? So it widens the scope. Okay. So 21 amendment has substituted the 43J, deleted the 8th schedule. This effectively means parties are free to appoint arbitrators regardless of their qualification. So this is the big thing. So you are now allowing foreign lawyers to practice as arbitrators in India, regardless of their qualification. Okay with that?
सर जैसे इंडिया का शिपिंग का जो है, इन लोगों का जो आर्बिट्री, जो इंडियन के लोगों को ही कमेटी, जो इंडियन शिप्स या इंडियन फॉर्म्स वाले जो हमारे जो आर्बिट्री के पास जाते हैं, और जो अगर इनको पसंद नहीं आए, मतलब इनको अच्छा नहीं लगा, तो ये लोग कोर्ट तक जाते हैं. तो ये जो बाहर वाले करेंगे और इनको जो आर्बिट्री का हम लोग जो अवार्ड मिलेगा, फिर उसके बाद कोई माना नहीं तो वो कहाँ जाएगा?
See, there is possibility for appeal against foreign award also, but again it will be limited. जैसे मान लो there is an award which is given by a foreign arbitral tribunal that is in some other country, but that award relates to some property or finance which is located in India. So where will this award now be executed? This has to be executed in India only, correct?
Yes.
Yeah. So the copy
Yes,
of the arbitral award has to be filed with the court, and the court has to see that this foreign arbitral award is executed in India. Same way, if an arbitral award is made in India and it has to be executed in some other country, same procedure. So with this order from India, they will approach the court over there, and then as per its laws, there will be only certain cases where a foreign arbitral award can be set aside. In most cases, in general, you will have to execute the foreign award also, right?
Okay, sir.
Because India will be part of an international convention, which we'll soon talk about. So all countries which are party to that convention will be at par with each other. Okay. So whether the award is in one country or in another country, as long as you are party to the convention, it is executable in any of the countries. Right?
Okay, sir.
Yes, sir.
Okay. Next, we will talk about what is called the ACI. So just write this one. The Amendment and Conciliation Act 1996. Okay, the amendment to the Arbitration and Conciliation Act 1996 in 2019. So this was the 2019 amendment, which mandated the establishment of the ACI, Arbitration Council of India. So this becomes the apex body in India, the Arbitration Council of India. So all these various, arbitration organizations like your ICA and all will fall under this ACI. So ACI is the apex body, right? So this has been set up by your 2019 amendment. So just write this Arbitration Council of India as a corporate body. Have you written this first line?
Yes, sir.
Yeah.
So this Arbitration Council of India and
Indian Council of Arbitration is just
Oh,
one of the bodies which can carry out arbitration in India. There are many bodies. Okay. So apart from the ICA, there are many other bodies also. ICA is the most popular for maritime affairs.
Okay.
But there are various bodies. Okay. So out of those bodies, whom to choose, how to grade these arbitral institutions. So for that, this ACI is coming in. Okay. Is it fine?
Yes.
Right. So
For ACI itself does not carry any arbitration. They are just supervise.
yeah, they will not carry out any arbitration, right?
Okay.
Okay. So ACI is headed by a chairperson. The chairperson will be someone who has been a judge of the Supreme Court or a Chief Justice or judge of a High Court or any eminent person, right? So ACI headed by a chairperson who can be judge of a Supreme Court, Chief Justice, or judge of a High Court or any eminent person. The chairman has to be appointed by the central government in consultation with the Chief Justice of India. Okay, so there is an apex corporate body being set up, and that is the Arbitration Council of India, or the ACI. And ACI, the chairman will have this qualification: chairman appointed by consultation between the government of India and the Chief Justice.
The Chief Justice himself can be the chairperson also. So
Right.
he
Can be the chairperson if there is an agreement, right? Okay. Shall we go on?
Yes, sir.
Yeah, good. And then there will be, other than the chairperson, it will also have 2 full-time members. Okay. These 2 full-time members will be among eminent arbitration practitioners and academicians. Just write up to this, and then after that you have got additional representative members. That is fine. So just the chairperson and 2 full-time members. 2 full-time members among eminent arbitration practitioners and academicians. Okay. Yes, please.
Yes, sir.
Yeah. Next, what is the purpose of the ACI, right? So just write the function of the ACI. Function of the ACI. First one, framing policies to grade the arbitral institution. So it will have a grading system. We will have a grading system for various arbitral institutions. So we can, as per the grade, we can see which one is better and which one is less. So this is probably the most important function, grading of arbitral institutions, which was not being done before. Second, to evolve policy and guidelines for the establishment, operation, and maintenance of uniform professional standards in terms of all matters related to arbitration and ADR mechanism. Hold training, workshops, and promote and encourage ADR. So first one was the important one, that is the grading, then policies, guidelines, training, workshop, promoting and encouraging ADR mechanisms.
Sir, in this ACI, in the beginning where you had started the 2019 amendment, there it was also written that it will propose new section to the Arbitration Act. So it is also a purpose of this ACI.
No. The ACI, here what it says is the ACI at the amendment proposes to insert 2 new sections for the incorporation of ACI. In the amendment to the Act, you are making the provision for ACI. If you want to set an ACI, then it has to be part of the Act itself. So in the Act, in 43 section, now they have added 43A to 43M, which talks about ACI, its constitution, its function, everything. Okay.
Okay, sir. Okay.
Right. So done with this? Yes, please.
Sir.
Yeah. So next, what we are going for is your how the foreign award will be executed, right? Okay, just write this ACI, right? Its head office will be in Delhi, right? Arbitration Council of India, the head office shall be in Delhi. So just to give you an idea, you can see India has over 35 arbitral institutions. So these 35 arbitral institutions, now we will have a grading. So if 2 parties have already chosen a common arbitral institution, like say if you have already said ICA, then ICA will be there. But if the 2 parties there is no agreement on the arbitral institution, then who's going to choose the arbitral institution?
Sir.
Register.
नहीं, रजिस्ट्रार की तो आर्बिट्रल इंस्टीट्यूशन रहेगा तब ना उसके रजिस्ट्रार के पास जाएंगे,
हाई कोर्ट।
तब आपको कोर्ट में जाना पड़ेगा, राइट? सो यू विल हैव टू गो टू द कोर्ट, डिस्ट्रिक्ट कोर्ट और हाई कोर्ट. And on what basis the court will suggest you the arbitral institution?
In your clause it is written.
On basis of the grading. And who has given the grading? The ACI. Is it okay now? The sequence?
Okay.
Yeah. Okay. Shall we go on?
Yes, sir. Yes.
Yes, sir.
Yeah. So now, domestic award, we have is just right that there are two parts of the Arbitration and Conciliation Act, right? So domestic awards is dealt with in section 2 to 43, and foreign award is dealt with in part 2. So what is asked is, what is domestic award, what is foreign award, how foreign award is implemented in India, right? So these will be the questions, right? So write the reference, then we'll have the definition of what is a domestic award and what is a foreign award. Okay, shall we go on?
Yes, sir.
Domestic award is a result of arbitration carried out domestically and confines itself to the territory of India. The conditions for the same are that the parties should have nexus or birth to Indian origin.
सर ये जो ट्रिब्यूनल है दैट 4 जो ट्रिब्यूनल अनक्लॉज में है, ये दोनों ये पूरे अलग है ना उसके साथ?
नहीं, वो जो ट्रिब्यूनल है that is for international dispute which has been that arbitration, your permanent court of that is a different setup, right? For international dispute as the final authority. Here we are talking about smaller things, that in the contract there is some provision for arbitration, then go to that country which is referred to there, follow the law, follow the particular arbitral institution. If not mentioned, then two parties agree to the institution. Still not agreeing, go to the court, court will suggest the institution on basis of the grading, which is given by ACI. Is it okay? Yeah. Done with this. What is domestic award?
Yes, sir.
Right. So in the domestic award, what is happening to the parties?
Should have a connection with India or Indian origin, but
Right. Next, an award given by an arbitral institution in India or an award even if given by a foreign state for a dispute where both parties are of Indian origin and nationality is governed by Indian laws and come under the purview of domestic arbitration. If the parties are Indians, if the companies are Indians and they are in dispute, whether the arbitration took place in India or the arbitration took place in some other country, it will qualify under the definition of domestic award.
Yes, sir.
Okay. The second is the foreign award. Foreign award is an arbitral award which relates to differences relating to matters considered as commercial under the law in force in India, and it is a result of foreign arbitration. So supposing there are two companies which are in dispute. Both the companies are not of Indian origin, right? Or at least one company is not of Indian origin, and this arbitration was carried out in some other country, and then the award is given, what kind of award it will be? Domestic or foreign?
Foreign.
Foreign award, right? Is it okay?
Yes.
Right. So one of the parties at least should be foreign. If both parties are foreign, then definitely foreign. At least one of the parties should be foreign. And the arbitration which is being carried out is being carried out outside India, not in India. Okay. So how to enforce the foreign award? So just write enforcement of foreign award. India is a signatory to the convention on the recognition and enforcement of foreign arbitral awards 1958. Write this, but at least remember this one. India is a signatory to the New York Convention. As well as the Geneva Convention on the Execution of Foreign Arbitral Awards 1927, or in short, the Geneva Convention. So India is a party to New York Convention. India is also a party to Geneva Convention.
सर अगर दो पार्टी में से एक इंडियन एक फॉरेन है एंड दैट आर्बिट्रेशन टेकिंग प्लेस इन इंडिया देन इट्स अ डोमेस्टिक और फॉरेन
Come again, if one of them
one of the parties is foreign, the other is Indian, and the arbitration is taking place in India.
arbitration is taking place in India, so Indian tribunal will give an award. Now this award will be executed where? If it is being executed in some other country, so for that other country this is a foreign award. Correct? Is it okay?
Okay, sir.
So if a party, just see, don't have to write this. If a party receives a binding award from a country which is a signatory to these conventions, and the award is made in a territory which has been notified as a convention country, the award will then be enforceable in India. So now if it is, you are a contracting state, the others are also a contracting state, so it doesn't matter where the tribunal was, where the award was given, the award is still enforceable in India because you are a party to this convention. Is it okay? This part?
Okay.
What about others? All good?
Yes, sir.
Yeah.
Yes, sir. Yes.
Yeah. So in this, just write this part, right? When a party is seeking the enforcement of a foreign award, so party comes to India and wants to seek enforcement of a foreign award, they are required to submit the following documents while making an application for the same before the court. So you have to approach the court to enforce that foreign award, and you will have to give some proof that yes, you have got the award from somewhere. Okay, so the party has to approach a court in India for the foreign award. Which court you will approach in case of foreign award?
High Court.
High Court, right? And what you have to produce? The original award or copy thereof, duly authenticated in the manner required by the law of the country. We need a copy of that award, right? The original agreement for arbitration, and such evidence as may be necessary to prove that the award is a foreign award, that it is qualifying for a foreign award. So whatever proof is required, so that you have to give. So in other words, you have to approach a court, the High Court, and you have to give all evidence that you have got a foreign award, and that foreign award should be enforceable in India as per the New York Convention or as per the Geneva Convention.
Sir, but in certain is there a possibility that High Court can put a stay on that foreign award?
Yeah, can put a stay. So that options are very few. So we'll see when it can be put and stay. Otherwise, what we said is it is binding, it is final, should be enforced in India, right? But there is still some, right, where you can stay it. Up to this is done. Yes, please. Yes or no?
Yes, sir.
Okay. So just take the last one, right? The condition for enforcement of foreign awards. Okay. Maybe. So are given under section 48, right? If the following conditions are approved, the enforcement of foreign award may be refused. So now you're getting this one, right? Where the enforcement of foreign award may be refused under the following conditions. So just write these three conditions where the enforcement of foreign award may be refused. The parties to the agreement were under some incapacity. The agreement in question is not in accordance with the law to which the parties have been subjected to. Failure to give proper notice for appointment of arbitrator. So you see similar conditions where you could have got a stay even in India.
Yes, sir.
Domestic awards, isn't it? So almost similar conditions for foreign awards. Let me know once you finish, right?
Yes, sir.
Okay, so done with this. So we finish arbitration here. Just write one, just for your knowledge sake, that there is something called UNCITRAL arbitration rules, right? So India's Arbitration and Conciliation Act more or less follows this. So just write this. This is your United Nations Commission on International Trade Law. Right? United Nations Commission on International Trade Law, which publishes the UNCITRAL. This is the UNCITRAL, United Nations Commission on International Trade Law, which publishes the arbitration rules. Right? And they are revised from time to time. Okay, done with the reference?
Yes, sir.
Sir, can you just show that last point, which condition for enforcement when it can be refused?
Yeah, this one.
Okay, sir. Okay, thank you.
Okay.